will be received. At this time, the chair is pleased to recognize the ranking member of the subcommittee, Mr. Steil.
Thank you, Mr. Chairman, and thank you to our panelists for being here this morning. Mr. Hearn, in your testimony, you stated that you served as an advisor on the Commission on Federal Election Reform, commonly known as the Carter-Baker Commission. The commission made a total of 87 election reform recommendations to increase voter confidence in the election process following the 2000 presidential election. And most notable was the commission's endorsement of a photo identification requirement to vote. How many members served on the Carter-Baker Commission, Mr. Hearn? Mr. Hearn? The pros, cons of an electronic hybrid. I'll answer the question. It's 21. 21 commissioners. Are you there, Mr. Hearn?
Yes, I am. I am here. There. Sorry, Member Stiles.
That's fine. There were 21 commissioners on the Carter-Baker Commission. It was bipartisan, Republicans and Democrats, correct?
That is correct. It included luminaries from this body like Lee Hamilton, Bob Michael, obviously President Carter, and Secretary Baker.
And how many members voted in support of the voter ID recommendation?
They all voted in support of it except for two members, Tom Daschle and Spencer Overton, who filed a supplemental statement in which they said they didn't support the use of the federal real ID as an identification.
So in summary, Democrats and Republicans on that commission in 2000, looking to increase voter confidence in the election, voted in favor of photo ID. Let me shift gears here slightly. I think one thing we can all agree on is that voting rights are important and that every single eligible person who wants to vote should have the opportunity to cast a ballot, and that every vote should be counted according to state law. And thankfully, our country's come a long way since the 1960s. And so I'd like to dive into the pre-clearance, which is really an extreme legal remedy. As Mr. Holder, as you're aware, in 2013, the United States Supreme Court declared the pre-clearance coverage formula unconstitutional in Shelby County because the criteria used were outdated and therefore violated principles of equal state sovereignty and federalism. And so the pre-clearance formula in the Voting Rights Act was based on 1965 election information, which had low turnout rates, in particular among minority voters. If a new pre-clearance formula was introduced, what would be your specific criteria to identify a covered jurisdiction?
Well, I think that what we'd have to do is do what the Congress did back in 1965, which is to conduct hearings as you're doing now, come up with ways in which you look at states that have
you're uniquely knowledgeable. You sit on a board, you study this. What would be the specific criteria that you would recommend Congress look at to determine who would be covered?
Well, I'd look at voter participation. I'd look at the way in which lines were drawn when it comes to gerrymandering, and gerrymandering has an impact on this whole question of keeping people away from the polls. If we look at the poll closures, 1,700 since Shelby County, 750 in Texas, 320 in Arizona, 200.
So I'm going to reclaim my time. I'm going to reclaim my time just because we're so tight on time here. So I appreciate that. Let me share my concern is that I don't know that how jurisdictions are going to know exactly whether or not they're in or out of this preclearance. And my concern is that every jurisdiction is going to find themselves under the role of the federal government, of continuing this push towards a federal government takeover of our elections. That's my concern. And Chief Justice Roberts noted that the Department of Justice is quote, famously opaque, and usually the states and municipalities have to go through or had to go through several layers of back and forth. It's sort of a bargaining process, end quote. So to me, my concern is that the Department of Justice is not going to be impartial. And in 2013, the Department of Justice Inspector General reviewed the DOJ hiring process and determined that 8 of the 9 new hires to the voting rights section had 1 or more liberal affiliations, and 2 of them had an affiliation with the Democratic Party itself. 5 of the hires had affiliation with 5 specific civil rights groups. 2 of the groups are providing testimony today. The IG also noted that none of the 10 candidates had conservative or Republican affiliations that were hired, and only 1 of 235 candidates with unknown affiliations was hired. But the observations of the DOJ hiring practice focused on specific partisan ideological affiliations, I'm concerned that states won't get a fair shake. And Mr. Holder, I know that in your testimony, you noted that you're not asking for favoritism towards any political party, but the group that you represent, the National Democratic Redistricting Committee, in their IRS filing, stated that the purpose of the organization is to build a comprehensive plan to favorably position Democrats for the redistricting process through 2022. Is that correct?
Yeah, to favorably place Democrats in a position to fight for fairness, and make sure that the process is indeed fair. We have to make sure that Democrats have the capacity to be on equal basis with their Republican opponents.
Understood. I think it's important to note the purpose of the organization that you represent. And Mr. Chairman, I'll wrap up by seeking unanimous consent to submit to the record Mr. Holder's organization's IRS filing with that purpose so stated.
Without objection.
Let me just say that is a mischaracterization of the intent of that filing. And beyond that, the notion that the Justice Department has conducted itself
saying that you unfairly uncharacterized yourself in your own IRS filing, that you misfiled.
You are unfairly characterizing that which we wrote. And and beyond that,
I'm not mischaracterizing anything. It says, describe the purpose of the organization. I quoted it in full.
The committee will come to order. As I used to say when I was a trial judge years ago, the witness may complete his answer. All right.
You can look at words and mischaracterize them. With all due respect, Congressman, you're looking at those words and mischaracterizing them. I'm trying to give you their true intention. And beyond that, more importantly, though, this notion that the Justice Department has somehow acted in a partisan way, Republican as well as Democratic attorneys general really enforced the Voting Rights Act during the course of its history. Every president who signed the reauthorization of the Voting Rights Act was, in fact, a Republican. The last reauthorization of the act was supported almost unanimously by Republicans and Democrats in the House as well as in the Senate.
Thank you, Mr. Holder. This time the chair recognizes Mr. Aguilar for 5 minutes.
Thank you, Mr. Chairman. I appreciate it. And I'll do something unique here. I'll answer